A very warm welcome to all. Today, I, Riya Khanna, a legal intern under Lexis and Company, am here to explain my topic, will and wasiyat under the Islamic law. Will is the Anglo-Mohammedan term for its Arabic equivalent wasiyat. Concept of will under the Muslim law. So, a will or testament or wasiyat has been defined as an instrument by which a person makes deposition of his property to take effect after his death. The distinguishing feature of a will is that it becomes effective after the death of the testator and it is revocable. Unlike any other disposition, example sale or gift, the testator exercises full control over the property bequeathed till he is alive. The legatee or beneficiary under the will cannot interfere in any manner whatsoever in the legator's power of enjoyment of the property, including its disposal or transfer. The object of will, according to the tradition of profit, provides for the maintenance of members of family and relatives where they cannot be properly provided for by the law of inheritance. At the same time, the Prophet has declared that the powers should not be exercised to the injury of the lawful heirs. A bequest in favor of an heir would be an injury to the other heirs, as it would reduce their shares and would consequently include a breach of the ties of kindred. Thus, the policy of Muslim law is to permit a man to give away the whole of his property by gift inter vivos, but to prevent him, except for one third of his estate, from interfering by will with the course of the devolution of property according to the laws of inheritance. A will offers to the testator that means of correcting to a certain extent the laws of succession and enabling some of those relatives who are excluded from inheritance to obtain a share in his property and recognizing the services rendered to him by a stranger. Further, generally, the trend among Muslims earlier was not to make a will or wasiyat. Hence, Islamic law thought it prudent to lay down a set of laws regarding disposal of property when a Muslim was on his deathbed. This is referred to as Mars ul Maut. Gift during Mars ul Maut is one form of testamentary succession. Gift during Mars ul Maut means a gift on the deathbed. When a person is very seriously ill and on the apprehension of death and he makes a gift at that particular time, then it will be a gift during the Mars ul Maut. And gift on the deathbed is a hybrid of hiba or gift of will. It includes some essential elements of will and some essential elements of gift as well. Therefore, we can say it would be open to say that a Muslim to transfer his entire property during his lifetime by way of gift to any person unless the gift is a marzul maut gift. Now, let's understand the requisites or the essentials of a valid will under Islamic law. The first is the testator or the legator. The second is the testatrix or the legatee. The third is subject, and the fourth is extent. Every major Muslim who is above the age of 18 years of sound mind can make a will. The age of majority is governed by the Indian Majority Act 1875, under which a person attains majority on completion of 18 years and 21 years in case of votes. At the time of execution of a will, that is, when it is being made, the testator must be of sound mind. And under Muslim law, the legator must have a perfectly disposing mind. That is, the legator must be capable of knowing fully the legal consequences of his activities, not only for a brief period, but when the declaration was made, but much after. A will that is executed in apprehension of death is valid, but under Shia law, if a person executes any will after attempting to commit suicide, the will is void. A minor is incompetent to make a will, but a will made by a minor may subsequently be validated by his ratification on attaining majority. A will procured by undue influence, coercion, or fraud is not valid, and the court takes great care in admitting the will of Pardonician lady. Thus, a will must be executed by a legator with his free consent. The legator must be a Muslim at the time of making or the execution of the will. A will operates only after the death of the legator. Before his death, it is simply a mere declaration on the basis of which the legatee may get property in future. Also, the will is governed by the rules of the school of Muslim law to which the legator belonged at the time of the execution of the will. That is all for today's video. We shall be understanding more about will under Islamic law in the next video. Thank you so much.